Welcome. My name is Michael Frumkin, and I'm the organizer of this University of Miami Law School seminar on the constitutional crisis. I'm delighted to welcome my old friend and former colleague, Steve Vladeck, to speak to us today about the role of courts and attacks on courts, a hot subject these days if there ever was one. Steve graduated from Yale Law School in 2004, where he was executive editor of the Yale Law Journal and won the Harlan Fiske Stone Prize for Outstanding Moot Court Oralist and shared the Potter Stewart Prize for Best Moot Court Team Performance. After law school, he clerked for Marsha Berzon on the Ninth Circuit. Steve is currently the Agnes I can't even say it, Sesquicentennial Professor of Federal Courts at the Georgetown University Law Center. But before teaching at Georgetown, he taught at UT Austin. And before that, he had an office very near to mine here at the University of Miami, and we still miss him. I learned today that while he was here, he also clerked for Rosemary Barkett on the 11th Circuit, so he had two federal clerkships. Steve is a co-author of the Aspen Publishers casebook on national security law and the author of the New York Times-bestselling book, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic, which won many awards, including the 2024 Order of the Coif Book Award. He's received many other awards for his influential and widely cited legal scholarship, his popular writing, his teaching, and his service to the legal profession. He's also an accomplished appellate advocate. He's argued before the U.S. Supreme Court and numerous lower federal courts and in military courts. Steve is CNN's Supreme Court analyst, an editor and author, and the editor and author of the online newsletter One First, which is a very popular and ostensibly weekly newsletter about the Supreme Court. But in fact, given all that's going on, it is a weekly newsletter only in name because it comes out more than once a week. I highly recommend it. If you subscribe soon, you have a chance to become the 100,000th subscriber, because last I checked, he's very close. I don't know if you get a prize, but you should. In his copious spare time, he's a member of the Board of Trustees of Amherst College, from which he received his BA summa cum laude with highest distinction in history and mathematics in 2001, and of Earth Justice, a nonprofit public interest environmental law organization. It is my enormous pleasure to welcome back Steve Vladeck, University of Miami, to speak today to us in the University of Miami Constitutional Crisis Seminar. I'm going to mute myself and turn it over to you, Steve. Go for it.
Great. Thank you, Michael. Hi, everybody. It is a real treat to be with you. As Michael said, spent the first 2 years of my career at UM. What he did not say is I met my wife at UM. She was not my student, let the record show. And it's a real treat to get to spend any time with UM students. So thanks for having me, Michael. So there's a couple things I really want to do in my talk today to set up the moment we're in, just to make sure we're all on the same page. So I'm going to spend a little bit of time, over the next, 45 plus minutes, which will end up closer to an hour, doing a little bit of history before we get to the last 9 months. So we can really put into context really how extraordinary a moment I think we're in when it comes to the relationship between the courts and the rest of the government, but also the vertical relationship between the U.S. Supreme Court and the lower federal courts. I've been doing this job this is my 21st year teaching. I'll just note that I think Michael's been doing it for 2 or 3 years longer than me. This is as remarkable and in some respects alarming, I think, a moment when it comes to that vertical relationship as anything I've seen in my career, and frankly, as anything I'm aware of in the Supreme Court's history. So, all right, let's start at the beginning. So the beginning is really the first 100 years of the U.S. Supreme Court. There's a lot of fairly well-tread history here, but the Supreme Court starts as a remarkably weak institution. In the Federalist 78, Hamilton talks about how it's going to be the least dangerous branch. It's going to depend upon popular support. It's going to depend upon a lot of political buy-in, right, in order to be able to discharge its duties. One of, I think, the most neglected examples today of just how much Congress kept the early Supreme Court under its thumb was circuit riding. So, some con law professors, when they teach Marbury, talk a little bit about circuit riding, but circuit riding was the means by which Congress made it not very fun to be a Supreme Court justice. One of the first justices to resign, Thomas Johnson, resigns because he accuses President Washington of misleading him about the travel obligations. right? Chief Justice Jay resigns in 1795 to become the governor of New York, which he called a promotion, because, right, the Supreme Court was viewed as this weak institution that had no power and that Congress basically dominated. And indeed, even in the huge conflict between the Jeffersonians, the Democratic Republicans, and the Federalists in 1801 and 1802, one of the ways that the Jeffersonians get back at the Supreme Court is by reinstituting circuit riding, right? Circuit riding persists technically all the way till 1911, but actually in significant form until the 1860s. Why do I start there? Because it's a really important example of just how much the Supreme Court's relationship with lower courts and the people for much of the 19th century was actually much the same thing. That part of why Congress required the justices to go out on circuit every year was because it wanted the justices to actually bring the law to the people, to be Republican schoolmasters, as one academic put it in the 1960s. This was accomplished in lots of ways. So the circuit courts of that era were where almost all federal criminal cases were brought, which meant that it was the circuit justice's job to do grand jury charges. Right? Circuit justices presided over many of the most important petty jury criminal prosecutions of that era. But also, right, sending the justices out on the road, guys, for as much as 6 months out of the year was also meant to humble them. Right. This was you probably cannot really imagine how bad transportation was in the United States in the early 19th century. So we're talking about like stage coaches, staying in public inns where it was like 6 to 12 people to a room. It was a sort of just keeping the justices like not very sort of confident in their station. That's just one example, right? But like this was not a coincidence, a period during which the Supreme Court was pretty weak. One of the reasons why, right, John Marshall famously uses Marbury versus Madison as the case in which he tries to cement the principle of judicial review is because he couldn't actually do that in a case that would have any consequences for Thomas Jefferson. Jefferson would have just ignored him. Indeed, right, Madison famously doesn't even show up in Marbury versus Madison. And so even Marbury, right, which we learn in law schools, the first time the Supreme Court ever struck down an act of Congress, it would be 54 years before there'd be a second. So, we read a lot of those early 19th century decisions, but most of them were about the relationship between the federal government and the states, and not so much about the relationship between the Supreme Court and the other branches of the federal government. My Georgetown colleague, Kevin Arlick, has a really lovely new book that actually explains that part of what the Supreme Court did during this time period to really burnish its reputation was to be really, really good at admiralty cases. Because it was the one thing everyone agreed the Supreme Court should be doing, right? That there were actually moments during the War of 1812 in particular in which the Madison administration wanted the Supreme Court to take this problem off of its desk. It really is a story of a court that is not a dominant institution and a court that is mostly dependent upon the other branches of government. One last data point. I don't know how much you guys know about where the Supreme Court has sat over the years. So Congress actually didn't even think to provide a permanent home to the Supreme Court until 1810, right? For the first, 20 years of its history, the court just like stole whatever swing spaces it could find. And the space Congress provides in 1810 is in the first floor, which most people would call the basement of the U.S. Capitol. Right. So if you've ever taken a tour of the Capitol, it's the old Supreme Court chamber, which is where the court sat from 1810 to 1860. I don't know how many of you guys are still living in your parents' basements or have lived in your parents' basements, but I think it's a pretty good reflection of the power dynamic, right, that the Supreme Court was in, not just the Capitol, where it sat till 1935, but actually in like what is basically the basement until 1860. Okay, the court behaves pretty responsibly, I think we can say, during this time period. I mean, other than Dred Scott, which is a pretty big exception, and like it's a remarkable example unto itself. The court, I think, did a lot during this time period to burnish its reputation, to build support. By the 1810s, right, Congress is no longer trying to destroy the Supreme Court. Congress is actually doing things like funding it and giving it a staff, right? The reporter of decisions, the person who's actually like tasked with telling the public what the Supreme Court has decided. It's first created in 1817. So, little steps just along the way, like, oh, there's a Supreme Court, we should be nice to it. And part of that might be reflection that the court was generally perceived, with some important exceptions, as largely respecting the separation of powers and participating in the system. Things get a little wild after the Civil War. So the Civil War, a couple of crazy things happen to the federal government. The first is the federal government gets much, much bigger, right? Just like the war itself, but also a whole bunch of regulatory programs that the federal government embarks upon during the war leads to a massive expansion just in the size of the bureaucracy. I live in Washington, D.C. D.C. really becomes a city during the Civil War, where it was like this weird, collection of enclaves before the Civil War. So that's part one. But also, it's not just the federal government gets bigger. The federal government starts doing a lot more stuff. And so before the Civil War, there are both sort of structural and political reasons why the federal government mostly left people alone, and why most of what the federal government did before the Civil War was, international trade, was admiralty, was sort of that kind of stuff, not domestic affairs. During the Civil War, Congress creates a Department of Agriculture to feed the troops, right? A Department of Education, right? A national currency, a national railroad. I mean, there's all kinds of ways, guys, in which the Civil War is not the cause, right? But in which it's sort of a focal point for the expansion of government. Of course, with the expansion of government comes the expansion of claims that the government is breaking the law. And so we also see this massive uptick in federal statutes and in litigation about federal statutes, on top of, right, the post-Civil War amendments, the 13th, 14th, and 15th Amendments, which at least for a period of time are also their own engines of litigation. The result is that federal court dockets explode in the early 1870s. So, hopefully your civil procedure professors out there taught you that Congress first provided for general federal question jurisdiction in 1875. The reason why it was 1875 was because federal dockets were exploding. And it was felt necessary, right, to sort of allow more of those cases in the federal court versus state court, right? Federal law was exploding. But one of the constants during this whole period was the Supreme Court, right? So starting in 1789 in the Judiciary Act and all the way through 1891, the Supreme Court's appellate jurisdiction, almost all of its workload, was directed by Congress, right? So today we think of the Supreme Court as picking and choosing its cases. None of that happened in the 19th century. Until 1891, all of the Supreme Court's appellate jurisdiction was what we call mandatory, meaning if the court had jurisdiction and if a party took an appeal falling within that jurisdiction, the justices had to hear it. So, no matter what, right? The justices might not have wanted the case. It might not have been important. It might have been almost frivolous. They still had to take it. That wasn't that big of a deal before the Civil War because there weren't that many cases in the lower federal courts, right? And so, the Supreme Court's docket, maybe in one year it had like 100 cases, but before the Civil War, it's mostly in the 40s and 50s, year over year. But as dockets blow up in the lower federal courts, right, in the late 19th century, the Supreme Court's docket blows up as well. So by the mid-1880s, right, the court has at one point 1,800 active cases on its docket, every single one of which it was required to hear. And Chief Justice, I think it was Fuller, reports to Congress in 1888 that the court was approximately 3.5 years behind on its work, right? That basically the docket had become such a crushing blow that the justices were running 3.5 years behind. Why is this important to a conversation about the modern crisis of the courts? Because it is that docket pressure that leads Congress in 1891 to restructure the entire federal court system with an eye toward taking pressure off the Supreme Court. So 1891 is when Congress creates the modern circuit courts as we know them. 1891 is when Congress all but abolishes the old circuit courts and therefore circuit riding, right? And one of the ideas of these new circuit courts was that they would have the power to render what were essentially final judgments in most cases, and that the Supreme Court's review would be in those cases discretionary. So 1891 is the birth of certiorari. Now, at first, certiorari was an experiment. The only categories it applied to under the 1891 statute were cases no one cared that much about, which interestingly included federal criminal cases, because This is before sort of the criminal procedure revolution, when those cases tended not to get that much excitement and interest. And so the experiment actually doesn't work very well because it doesn't take enough pressure off the docket. Like, giving the court a little bit of control over its docket doesn't help the fact that the pressure is expanding and expanding. Indeed, when the Supreme Court in 1905, in the Lochner case, invigorates the due process clause of the 14th Amendment as a basis for striking down economic regulations, that puts even more pressure on the court's docket, because now there are lots of due process cases, right, coming to the court. So by the 19-teens, the court is back into the same crisis. And it's at this point that our hero, or anti-hero, depending on your perspective, comes onto the scene. And his name is William Howard Taft. So Taft is, I think, the most neglected figure in the history of the Supreme Court. Right? I suspect you guys either haven't read any of his opinions, or if you have, it was maybe one in con law. Maybe you read Myers. Maybe you read Olmsted in criminal procedure. Right? But that's it. So Taft, of course, is president first, right? He's president from 1909 to 1913, when he apocryphally, I think I need to say, gets stuck in the White House bathtub. There's no actual evidence that this happened. But even before he was president, while he was president, and after he was president, Taft was deeply invested in giving the Supreme Court more power and more independence. That Taft thought that the court was too beholden to the other branches of government. Basically, that the court had never been allowed to fully flex its independent muscles. And so Taft identifies three big things he wants to do to the Supreme Court. The first, and perhaps the sort of most straightforward, is get it the hell out of the Capitol. Right? So Taft is the real progenitor of the idea that the Supreme Court should have its own building. He starts lobbying for this while he's president. And indeed, the money gets appropriated for it while he's Chief Justice sometime thereafter. The second thing Taft wants is he wants the judiciary as a whole to have an administrative organizational system. He basically wants to bureaucratize, right, the judiciary. And so Taft is instrumental in getting Congress to create what is today known as the Administrative Office of the U.S. Courts and the Judicial Conference, which is the policymaking body of the U.S. courts, and giving the federal judiciary basically its own lobbying, its own sort of rulemaking, its own political ability that it didn't have as a coordinated whole previously. But the most important thing Taft pushed for was an expansion of certiorari. So far beyond the four small categories in the 1891 statute, Taft thought the court's entire docket should be discretionary. And so he sets out to persuade Congress of this as well. So Taft, he's president until 1913. He goes back to Yale Law School for a few years, biding his time because he really, really wants to be Chief Justice. The only job Taft wants, and this was true even when he was running for president, right? The job he wants is Chief Justice. So much so that when the Chief Justice, I think it was, again, Fuller, dies in 1910 while Taft is president, Taft breaks from tradition to nominate a sitting justice, to nominate a Democrat, he's a Republican, right? And to nominate a guy who was at the time 65 years old, right? Edward Douglas White, to become the Chief Justice. There's no proof that Taft did all of this because he thought, he would outlive White, but it certainly worked out that way. So White dies in 1921, and the new Republican president, Warren Harding, appoints Taft as Chief Justice. Almost from the moment Taft is Chief Justice, right, he is pushing Congress to expand certiorari. And this culminates in a statute known blandly as the Judiciary Act of 1925, but known colloquially then and since as the Judges Bill. Why is it known as the Judges Bill? Because the judges wrote it. Right? And the idea behind the Judges Bill was simple enough that most of the court's jurisdiction should be discretionary. Now, Taft did not get everything he wanted. So actually, the court still had a whole bunch of mandatory appellate jurisdiction until 1988. But this was really the turning point. This is when the Supreme Court starts being able to sort of consolidate its power. It is not a coincidence, guys, that in your con law classes, the majority of cases you read are from after 1925. Right? The court that has more control over its docket is a court that can be pickier about the cases it decides. It's a court that can worry less about the next generation of cases after it, for example, holds that like the Eighth Amendment applies to the states or the Fourth Amendment applies to the states. And so it's not that hard to sort of draw a straight line from giving the Supreme Court more and more control over its docket to a lot of the con law that we learn in law school, and then, forget for the bar. Okay, that's sort of the first part of the story. Now, the rise of sort of the modern court also includes the rise of certiorari. And the reason why this is important is because you guys probably by this point have a pretty good sense of how much that basically puts behind the curtain, right? Puts behind the black box some of the Supreme Court's most important decision-making processes. There's an entire body of sort of literature about trying to sort of demystify the cert process, the timing of the cert process, like what a good cert petition is, what a bad cert petition is, how the Supreme Court processes cert petitions, how you get the court to, like all of this, amicus practice, I mean, you name it. And there's a ton of stuff here. And guys, it is all, right, like norms. Even the most important feature of certiorari, the idea that it takes 4 votes to grant certiorari, so 4 justices to take up a case, that is often referred to as the, quote, rule of 4, unquote. That rule is not memorialized anywhere. The only place you could cite as an authoritative public statement is, opinions referring to the fact that, like, only 3 justices voted to grant certiorari. Right? This is the shift, that the court with more power is also a court that is given more control and more ability to operate behind the scenes. All right. The fast forwarding to the end, right, is 1988. So in the 1970s, 1980s, because of a bunch of sort of shifts in civil rights litigation and criminal procedure litigation, the court's docket starts getting big again. So by the early 1980s, the Supreme Court is deciding 150 to 170 cases a term. If that number sounds wild to you, it wasn't to the people of that era, right? I mean, you ask the folks who clerked on the Supreme Court in that era, and they're like, these guys today, they don't do anything, right? But by the mid-1980s, it was perceived that that was too much, and that it was time to get rid of the rest of the court's mandatory jurisdiction. So in 1988, with very little fanfare, with almost no, I think, attention outside of the legal universe, Congress passed a statute that took away the rest of the Supreme Court's mandatory jurisdiction, except in those cases that still have to be resolved in the first instance by so-called 3-judge district courts. So those are special courts that sit only to hear constitutional challenges to congressional districts and certain challenges to campaign finance regulations and nothing else. In other words, right, 99% of the Supreme Court's docket today is discretionary, meaning, right, 99% of what the Supreme Court does is what the court wants to do. That obviously has massive ramifications for the court's relationship with the other branches of the federal government. It has massive ramifications for its relationship with the states. It has massive ramifications for its relationship with lawyers and with the people. And I think those implications are not often appreciated. So let me just give you one, I think, relatively recent, powerful example of how big of a deal cert can be and cert denials. So if I were to ask you which Supreme Court decision legalized same-sex marriage, you would all probably say Obergefell, I assume. Hopefully that's what you learned in common law. Okay. It turns out that by the time Obergefell was decided in June of 2015, same-sex marriage was legal in 37 states, and that actually there were only 13 states that were directly affected by the ruling in Obergefell. How'd that happen? So in those 37 states, 19 of the 37 legalized same-sex marriage on their own. And so whether through ballot initiatives, through constitutional amendments, or through judicial decisions by their state Supreme Courts, those 19 states did it on their own. Massachusetts was famously first. But guys, in more by Obergefell, same-sex marriage became legal the day after the Supreme Court denied cert petitions from the states, right? So in all of those states, you had the same thing happen. You had a lawsuit challenging the state's marriage ban. You had a district court issue an injunction blocking the marriage ban, and you had the state appealing and the Supreme Court denying cert. In other words, right, the Supreme Court legalized same-sex marriage in more states through cert denials than through Obergefell. I suspect you did not know that, right, before this presentation. Example, right, of one of the many, many ways in which the cert process produces massive effects. And guys, massive effects that are not explained, right? If you guys have ever seen an order granting or denying cert, it literally just says the petition for writ of certiorari is granted or the petition for writ of certiorari is denied, and there's no explanation. We don't know the votes, right? We don't know the details. That's just how the court rolls. Okay, that gets us to the court we have. So before turning to the sort of the emergency docket and how it has provoked the current crisis, what that has meant is that over the last 35, 36, now 37 years, the Supreme Court has gained just about complete control over everything it does. And so one of the things that has happened as a result is the court's docket has shrunk. I mentioned that in the mid-1980s, the court was hearing 150 to 175 cases a term. After 1988, so after it became almost all cert, there was an immediate drop into the 90s, right? So the court in the early 1990s was hearing and deciding somewhere between 85 and 95 cases per term. And that stayed pretty flat all the way into the first decade of the 2000s when I was in law school and when I started at Miami. And then, right, starting around 2012, it started ticking down again. And so the court today is deciding somewhere between 53 and 59 cases a term. That's been consistent over the last 6 terms. Before the October 2019 term, you'd have to go back to 1864 for the last time the Supreme Court decided so few cases. Right, so a court with power has the power to do nothing and has the power to sit out of the case it doesn't want to decide. And I think, and I'm happy to talk about this more in the second hour, but I think that that is a sort of not that sort of unrelated consequence, right? Or not an unrelated cause of some of the downturn in public confidence, right? That a Supreme Court that is doing more of the cases it doesn't want to take, right? A Supreme Court that's taking more of the sort of technical lawyerly disputes is one that might not split ideologically, right? Quite as often as the current court does. All right, so that's sort of the how we got from there to here. Really quickly before turning to the emergency side of stuff, it's not just with regard to Congress's control of the docket that Congress has surrendered control of the Supreme Court. The other areas historically where Congress pulled levers to keep the court in line, one was the building, and Taft took care of that. The other was the justices' pensions. So, I suspect that you guys haven't spent that much time thinking about your retirements yet. Right? But this was actually a huge deal in the 19th and early 20th century for public officials. So you had this concern that justices in the 19th century were staying on the court past maybe their most, past their sell-by date, right? Because they had no salary, right? Because they had no means of supporting themselves. Congress after the Civil War first provides, in some cases, for pensions for justices who retire after reaching the age of, I think it was 75 in the first statute, and had served on the federal courts to that point for at least 10 years. So that covers a bunch of the justices. It does not cover all of them. One of my favorite statutes, and I realize that you guys probably don't walk around with a list of your favorite statutes, but one of my favorite statutes is a 1-paragraph statute Congress enacted in 1882 that basically says this. It says, "Dear Justice Ward Hunt, we would like you to retire." Hunt, by the way, at that point was not eligible, right, for a pension under the post-Civil War statute. "Ward Hunt, we'd like you to retire. If you retire within the next 30 days, we'll give you a pension. Love, Congress." That's a paraphrase of the statute, but I don't think it is an unfair paraphrase. Shockingly, Ward Hunt retired, right? Like, he took the money. This was, guys, just one of the countless examples of how Congress used its powers to nudge the court, right? To nudge justices off the court, to shape the court, to keep the court in line, that the court was looking over its shoulder. And one of my favorite examples of that was when Abe Fortas resigns in May of 1969. He resigned because Earl Warren goes to him and says, "Abe, you have to resign for the good of the court or else Congress will come after us," right? It was like the external pressure of what Congress might do to the court that pushed Fortas to resign in this, awkward ethical kerfuffle. Okay, on the pension front, right, Congress gave up in 1937. So in the middle of the FDR court packing contretemps, Congress passed a permanent retirement bill for the Supreme Court. Meaning, right, Congress provided a permanent mechanism by which every single justice, once they retire, is entitled to a pension. Meaning, Congress no longer has leverage to go to an individual justice and say, no pension for you, right? Because that would be diminishing their salary. This is quite striking, and also, sort of a subtle but significant surrender of a lever, right? Certiorari is a surrender of a lever. Congress has stopped using the court's budget as a cudgel. The Supreme Court's operating budget for FY 2024 was $151 million. So, of course, Article 3 protects the justices' salaries, but those salaries account for about $3 million in that budget, meaning 98% of that budget is non-constitutionally required appropriations. Imagine a universe where Congress made, right, the sort of court's receipt of some or all of its budget conditioned upon the court adopting a code of ethics. There are levers Congress historically pulled that it has stopped pulling. All right, this brings me to, I think, the real source of much of our current conflict, which is one particular and historically largely ignored part of the Supreme Court's docket, which is the emergency docket. So when Professor Frumkin introduced me, he mentioned the title of my book is The Shadow Docket. The Shadow Docket is a term that Will Bode, a professor at Chicago, coined in 2015, not as a reference to the emergency side of the court's docket, but as a reference to all of this procedural stuff, to everything the court does through orders. I think that's important because, the emergency docket is the flashpoint du jour, but there's other stuff the court does that's really important other than its substantive opinions in these cases. But for various reasons, the emergency docket has become the flashpoint. All right, so a little more history, and then I'm done with history. But a little more history is to put the current moment in context. The court has had, if not a robust, then at least a sort of clearly existing emergency docket, at least since 1925, at least since the Judges Bill, because that was the first time Congress expressly provided for what's known as emergency relief, right? It's the first time Congress expressly gave justices the power to issue stays of lower court decisions. The court surely had that power beforehand, but there are very, very few examples of the court exercising it. And at least, guys, from 1925 all the way into the early 1980s, the model for emergency relief, the model for getting a justice to adjust the status quo while a case worked its way to the Supreme Court, was heavily dependent upon individual circuit justices. So we don't have circuit riding anymore. We still have circuit justices, right? So each justice is responsible geographically for 1/9 of the country. You guys may know Justice Thomas is the circuit justice for Florida and the 11th Circuit. I leave to you whether you are excited about that or not, right? Well, in the old days, that used to be a much bigger deal because applications would go to the circuit justice and they would stop there. And the circuit justice would very, very often hold argument, what were known at the time as in-chambers oral arguments, because many of them were literally just these informal affairs in chambers, right? One of my favorite stories is in 1948 when LBJ was trying to, I believe the technical term is steal or maybe out-steal the 1948 Texas Democratic Senate primary. Right? There's actually an in-chambers oral argument before Justice Hugo Black that's literally in his chambers. That actually ends up being a really important part of the story. Black ends up granting a stay. The stay allows LBJ to appear on the ballot, and the rest is history. Just one really small footnote here. In 1966, when LBJ is president, they have a birthday party for Black, an 80th birthday party at the White House. And LBJ puts his arm around Justice Black. LBJ, who is large and intimidating, Black, who is tiny and Alabamian, right? And says, if it weren't for this man here, we might be having this party, but it wouldn't be at the White House. Right? Even LBJ remembered. Anyway, the point was in-chambers arguments and in-chambers rulings were the norm, even when they had, as in LBJ's case, pretty big statewide consequences. That had both some features and some nice constraints. The features were one justice was a lot more flexible than 9, right? Very easy to track, or at least easier to track down one justice than the full court. One justice, much easier to have an argument than getting all 9 together. One justice could write an opinion, and no one would confuse what one justice wrote for an opinion of the full court. No one would think that, Justice Douglas, for example, was speaking for the full court, or that Justice Rehnquist was speaking for the full court, right? Like, it was a nice way of splitting the difference between someone who could act without necessarily doing more than was necessary under the circumstances, right? That was the upside. And in those very, very, very rare cases where the emergency was so dire that it required the full court, they would not resolve it through an emergency application. They would grant what's called certiorari before judgment. So they would basically take an expedited merits appeal from the district court and hold oral argument and decide the case on the merits. And guys, your common law casebooks are, full of those cases. So the Nazi saboteurs case during World War II, Youngstown in 1952, right? The Watergate tapes case, the Pentagon Papers case, the Iranian hostage case. Like, every 10 years or so, there would be one of those cases, and they'd have it resolved through plenary review. This model holds pretty well all the way into the late 1970s. And then two things happen that kill the model. And those two things, in retrospect, are actually pretty important for how we got to where we are today. So the first thing is there's one very, very, very visible example of two circuit justices disagreeing with each other, which was the one flaw in the system, right? So usually you would go to your circuit justice, the circuit justice would resolve the case, and that would be it, right? Now, right, you could also, but the rules allowed you to ask a second justice for relief as like a fallback. Well, there's a famous example in 1973 where plaintiffs are trying to stop the bombing of Cambodia, and they get an injunction from a district court. The Second Circuit stays the injunction. Justice Marshall, who was the circuit justice for the Second Circuit, refused to vacate the stay, so he keeps the ruling paused. And then Justice Douglas says, nope, I'm vacating the stay. I'm putting the injunction back into effect, only to have Marshall basically overrule him and say, I've spoken to the other justices by telephone, and they agree. That's literally written in Marshall's opinion. That was not a great look for the court. But the more important pressure point was the death penalty. So, the death penalty, the Supreme Court had imposed what was effectively a nationwide moratorium on capital punishment in 1972, but it brings capital punishment back 4 years later in 1976. And the thing about the death penalty post 1976 is it has a bunch more rules. It was hyper judicialized, meaning like there were all kinds of new claims that the hundreds and thousands of people, not hundreds of thousands, hundreds and thousands of people who are on death row in all of these states could litigate, usually through the form of a last-minute request for a stay of execution because their prior litigation had terminated. So there's a massive spike almost overnight in emergency applications to the Supreme Court in capital cases. And that's what puts pressure on the court to sort of move away from the circuit justice model, right? The death penalty was divisive. The justices had very strongly different views about the death penalty. And the justices did not think, understandably, right, that it would look good for the court to have some of those applications going to, say, Justice Marshall on the one hand, and some of them going to Justice Rehnquist. Like, that would not, go well for the court as an institution. So starting in 1980, two things happened. One, the court stops adjourning. Right before 1980, when the justices rose for their summer recess, the court formally adjourned, meaning it was not legally enabled to hand down rulings over the summer. It actually couldn't. It stops adjourning, right? So the court switches very quietly to a continuous term in 1980. Two, and much more importantly, the justices start referring any potentially divisive applications to the full court. And so you start to see a real uptick right around 1981 in how many cases are resolved by the full court on emergency applications versus individual justices, but without any sort of commitment, right, to holding oral argument or to writing opinions. And so because it's the full court looks for its most parallel example of how it issues orders. And the parallel example is certiorari, where the orders are not signed and where the orders are not explained. The last in-chambers oral argument that we're aware of was in May of 1980, right? The in-chambers opinions have also largely died out. There's only been one issued by a justice since 2014, right? These are symptoms of this shift. So the court shifts to like full court resolution of emergency applications without committing to writing opinions, without holding oral argument. There's no full court oral argument on an emergency application between 1971 and 2022, right? And no one really notices the shift because it's in the context of capital punishment, right? It's the death penalty, and death is different. You ask anyone who clerked on the Supreme Court in the 1980s, 90s, and 2000s, they'll say, yeah, it was the death penalty. And that was like dramatic and important and controversial, but it was just the death penalty. Maybe every once in a while there were some election cases, but that was it. Then, right, and now let me sort of get us closer to the present. Then, right about the mid-2010s, the court starts receiving and starts showing a willingness to grant emergency applications that are not about the capital punishment and they're not about elections. Rather, these are emergency applications where the emergency, right, is the effects either of a challenged state or federal policy or of a lower court ruling blocking it. And so the first really, really significant example of one of these is Obama's Clean Power Plan, which is blocked in an unsigned, unexplained 5-4 ruling by the Supreme Court in February 2016. That order has the what's the word I'm looking for? Distinction of being Justice Scalia's last vote, right? That he died a couple days later. And like, that's a real marker, right, in the history of the court. It really, though, ticks up during the Trump administration. So just to put this in context, right, the Solicitor General, the government's lawyer, during the Bush and Obama administrations, two, I think we can all agree, slightly different two-term presidencies, files for emergency relief a total of 8 times. So that's 8 times in 16 years. I know we all went to law school, so we would not have to do math. But I think we can do that one once every. I was a math major too. It's once every 2 years. The first Trump administration blows that up. So the first Trump administration, starting with the travel ban, goes to the Supreme Court for emergency relief over and over and over again. By the time it's done, it had gone 41 times in 4 years. So we went from once every other year to once every like 7 to 8 weeks. That's a pretty big uptick. That's a lot of how the court shows willingness, right? The court granted 28 of those requests in full or in part. Only 2 of them produce majority opinions, right? And so some of the sort of pathologies that we associate with what the court's doing today really start in 2017, 2018. And I don't think it's a coincidence, right, that the real sort of curve starts getting much, much steeper in the fall of 2018 when Justice Kavanaugh replaced Justice Kennedy on the court. Okay, even then though, right, even with the volume going up, the court was still mostly sort of, not resolving major separation of powers cases. Most of the Trump cases were about one of 2 things. They were either about whether immigration policy should be allowed to be in effect or blocked for the duration of litigation, or they were about the federal government's attempt to resume the federal death penalty at the end of 2020 and 2021. There were 13 federal executions between July of 2020 and January 2021. All of them, right, produced emergency applications in the Supreme Court. Okay, the Biden things slowed down a bit during the Biden administration, but even by historical standards, it's still a lot. The Biden administration goes to the court for emergency relief 19 times over 4 years. But also an important part of the story, there are a number of cases where other parties, states or private parties challenging the Biden administration, right, go to the court for emergency relief when the federal government won below. So the court had sort of normalized at least some of this volume. And even then, though, I think what's happened over the last 9 months has been totally unprecedented. So this brings us right to January. There had been, mounting criticism of the court's behavior on emergency applications. Some guy I know wrote a book about it, right? But like it had mostly been viewed as like largely under control. There was some evidence that the court was maybe taking some of those concerns seriously. We had seen maybe fewer of those straight 6-3 ideological splits late in the Biden administration on emergency applications. And then Trump came to office. So I mentioned the numbers, right? 8 from Bush and Obama over 16 years, 41 during Trump 1, 19 during Biden. So as of last week, right, we're now up to 30 emergency applications from the Trump administration since January. So we've gone from once every other year up to 2017 to basically once every 9 days. That is a stunning shift, right, in what the Supreme Court is doing on a daily basis. And it is, even the volume, I think, is a story unto itself. But it's not just the volume, right? The volume, I think, is indicative of a broader phenomenon, which is that since January, the Trump administration has, as it would be the first to tell you, embarked upon an unprecedented amount of changes in regulatory behavior, in government action, in claims of executive power. And that behavior, in turn, has provoked an unprecedented amount of litigation. Right. The last time I looked at the stats, which was about 10 days ago, there have been somewhere north of 150 different cases in which district courts have blocked Trump administration policies. Another 50 where they haven't. Right. So like 200 cases where different Trump initiatives have been challenged in court. Those 150 cases have come from 106 different district judges sitting in 29 different district courts. Appointed by every single president, including Trump, going all the way back to Jimmy Carter, right? So we've seen really a remarkable and unprecedented amount of litigation and an unprecedented amount of district court rulings blocking the executive branch. It is from those, right, that we've seen the administration go to the Supreme Court 30 times for emergency relief. All right, so let me just sort of, without walking through all of those examples, let me sort of identify what I think are a couple of important themes that have emerged from the court's rulings and that I think have gotten us to the crisis that I think we're currently in, because it's coming. So the first theme is that the court has not been writing. Right, I mentioned there have been 30 applications. The court has granted the last 23 of them for the Trump administration, so 23 consecutive grants of emergency relief. There have only been 3 majority opinions in those cases. And not only that, but 2 of those majority opinions were quite short. One was like 600 words, one was 900 words, right? These are not lengthy majority opinions. Not writing is a problem, I think, in a couple of respects. We'll get to one of them in a minute, but just from the perspective of like telling us what it's doing and providing guidance, I think the not writing is a problem. Let me take one example. In the Department of Education downsizing case, this is the case known as McMahon versus New York. When the Trump administration went to the Supreme Court for a stay of a district judge's injunction that was blocking the downsizing, it offered 3 different reasons why the government thought it was likely to win on the merits. One was standing, that these plaintiffs couldn't show that they were injured. One was a sort of administrative exhaustion argument that they had to go through the Merit Systems Protection Board first. And one was the merits, that on the law, right, they had the power to do what they were doing. Those are 3 very different arguments that would have 3 very different sets of consequences, depending upon which one the Supreme Court embraced. The court didn't say, right? It issued a boilerplate order saying, we stay in the district court's injunction, we're not telling you why. Right? Well, what is a district judge to do? Same thing has happened, right, in other contexts. So that's the first piece of this, right, is the not writing. The second piece is much, much more than we saw during the first Trump administration. These specific rulings are having not just big real world effects, but big separation of powers effects. So in the first Trump administration, there were almost no emergency applications in which the claim was that the president was defying a statute, or that the claim was that the president was aggrandizing Congress's appropriations power. Most of the applications were sort of classic administrative law, the executive branch is exceeding its statutory authority type of arguments. That hasn't been true since January, right? So President Trump has used emergency applications to argue that every single statute imposing a 4-cause removal restriction on an executive officer is unconstitutional, pushing the Supreme Court to revisit Humphrey's executor. Right, the AVAC cases, the AIDS Vaccine Advisory Council cases, have involved efforts by the president to impound and to engage in pocket rescissions of congressionally mandated appropriations in the foreign aid funding space. And so this has led the Democratic justices in dissent, and especially Justice Kagan, to criticize the justices for basically enabling, even as they're not writing, a pretty massive shift of power from Congress to the executive branch. Okay, the third piece of this is irreparable harm, right? So one of the really striking things about the doctrinal move the court appears to be making in these cases is the view that the executive branch is harmed whenever any of its actions are blocked by a lower court. Well, if you reverse engineer this, the origins of this idea are a series of opinions that then Justice Rehnquist wrote in chambers in the late 1970s, where Rehnquist says statutes come to court with a presumption of constitutionality. And so when a district judge blocks a statute, right, we should assume that that injunction causes irreparable harm. So listen, that's, folks can debate whether that follows or not. But the key is it's tied to the idea that the district court is blocking a statute. What is so striking about the Trump 2 cases is that none of them, right, involve blocking a statute. Indeed, some of them are lawsuits to enforce statutes, where presumably if we cared about the presumption of constitutionality, the calculus should cut the other way. Right? The irony is that the Supreme Court is acting as if the executive branch is the government. And as Justice Kagan put it quite sarcastically in the Wilcox case, I thought Congress was part of the government too, right? Apparently not. All right, 2 more points. Fourth, right? Or I guess 3 more points, sorry. Fourth, right? The court is also, even with that irreparable harm backdrop, it is refusing to actually balance the equities. So historically, right, when courts are fashioning emergency relief, what they're supposed to do is they're supposed to take, like, are you likely to win? And if so, is it worth, like, how imbalanced are the equities? Like, how much harm would I cause by blocking the lower court ruling? How much harm would I cause by not blocking the lower court ruling? That's literally what balancing the equities is. Well, the court has started doing this thing where as long as both sides have what Justice Kavanaugh calls strong claims of harm, then there's nothing about. Then they've thrown up their hands at trying to balance them, and they've just gone straight to the merits. Let me give you one example of this. So you guys probably are loosely familiar or very familiar with Vasquez-Perdomo. This is the Los Angeles area ICE raids case. There's no majority opinion, but Justice Kavanaugh wrote a concurrence where he suggests that the balance of the equities sides with ICE being able to continue carrying out these stops based on these 4, deeply problematic criteria. And to get there, right, Kavanaugh says there are at least 2 million undocumented immigrants in the Los Angeles area. And the government obviously has a very strong interest in, arresting, detaining, removing those folks. He leaves out, right, that on the government's own criteria, there are at least 9 million people who live in that same geographic area who would be subject to being stopped and detained and could not lawfully be arrested, right? And so as hard as it might be in some cases to balance the equities, 2 million, 9 million, like I think we can do that math. Right? That's not to say that that should have been conclusive. It's just to say that this is what happens when the court just abandons the field of trying to balance the equities. All right, last 2 points, and then we'll get to the crisis. Fifth, right, the court is for the first time treating these orders, even the ones that are not explained, as precedents. So starting in the Boyle case, the Consumer Product Safety Commission case from July, the Supreme Court not only stayed a lower court ruling, but sort of gently chastised the district court because they said this ruling was clearly controlled by our ruling in Wilcox. In Wilcox, there was no majority opinion, right? In Wilcox, there was almost no analysis. And in Boyle, the court says, when we grant a stay, lower court should, assume that the equitable factors cash out the same way in like cases. The court literally said in like cases. Guys, the whole job of lawyers, right, is to decide whether case B is like case A. Just asserting that it is doesn't quite do the work. All right, and then that brings us to the one that I think really set off the lower courts and has, I think, brought this conflict to a boil. And that's, I did not mean that pun. Right? And that was Justice Gorsuch's concurrence in August in the NIH case, where he says not only are these precedents, but district courts that aren't following our precedents are defying us. And so Gorsuch, in an opinion joined in full by Justice Kavanaugh, accuses 3 different district judges of openly, his verb, not mine, defying, right, the Supreme Court because they did not follow thinly or completely unexplained orders, right, in other cases in their rulings. It's ironic because even in that case, 5 justices disagreed with Gorsuch. But I think it's not a surprise that it was that opinion that led to a whole bunch of loud complaining from lower court judges. So 2 points on that. First, right, you might have seen some of these media reports, one from NBC in September, one from the New York Times a couple of weeks ago, where you have now literally dozens of lower court judges from across the ideological spectrum publicly complaining about the Supreme Court's behavior, right, and complaining about the court basically trying to have its cake and eat it too in these cases. Now, it may not strike you as that shocking that lower courts would object to something the Supreme Court's doing. I'll just say, in my experience, those objections are usually substantive, right? Like, I, Judge Smith, don't agree with the ruling in Johnson, right? But I am bound to follow it. That's the typical objection, right? The stuff that the New York Times and NBC are reporting is stuff I've never heard before. Right, one judge referred to the relationship between their district court and the Supreme Court right now as a war zone. One referred to it as a judicial crisis. We've seen this not just in anonymous quotes in newspapers. Judge Allison Burroughs in the Harvard case used a very long footnote to take a very, very healthy shot at Justice Neil Gorsuch. There's actually a case last week where a federal judge in San Antonio, Texas, dismissed a criminal indictment and took a shot at the Supreme Court along the way for Vasquez Perdomo, right? And so, we are really seeing lower courts publicly expressing frustration. There was an oral argument in the en banc Fourth Circuit in the Social Security Doge case, where half the argument was the judges just publicly complaining about the Supreme Court's behavior, right? Not, I should say, not denying the Supreme Court's authority to do what it's doing, right? Not denying the court's power to stay their rulings, to reverse them, but criticizing the manner in which the court's doing so. And this strikes me as really, really significant because this is all coming at the same time as we are seeing unprecedented efforts by the president and his supporters, right, to attack lower courts, right? That as the lower courts have been so aggressively pushing back against the Trump administration, they've become targets themselves. Pamela Bondi, the attorney general, has filed a formal misconduct complaint against Jeb Boasberg, the chief judge of the DC District Court. It's about the most ridiculous misconduct complaint I've ever seen in my life. This week, right, Republican senators are again on the Boasberg tour complaining about impeaching him and suggesting they should impeach him. This actually led Chief Justice Roberts back in April to say we don't impeach judges just because we disagree with them. We appeal. For John Roberts to say anything publicly, I think is a pretty powerful sign of where we are. And so I think part of the concern is not just this disconnect between the Supreme Court and lower courts. It's that when the Supreme Court throws lower court judges under the bus, they're providing fodder and ammunition to Stephen Miller and his supporters who claim that every single ruling against the Trump administration is evidence of what Miller has called, in his words, a judicial insurrection. And so this, to me, is the real crisis, right? That we have the lower courts doing what, to me, is a remarkable job of standing up for the rule of law, of enforcing legal constraints against the executive branch, rulings that, by the way, by and large, are being followed. I mean, yes, there are some high-profile cases in which the government appears to be defying district courts, but there are actually far more cases where it's not, and where the government is taking the loss and either not appealing or appealing about as slowly as it possibly can, right? So, those cases are happening, and yet we're still attacking lower courts. I think we saw this even too during the CASA oral argument, the birthright citizenship cases, where, the court was less troubled by the specter that the Trump administration might ignore a circuit court ruling than that it might ignore the Supreme Court itself. And it seems to me that from the Supreme Court's perspective, this is a sort of two-faced problem. The first part of the problem is that the more the court is undermining lower courts, the more the court is making life harder for the district judges, the more the court is criticizing district judges, the more it is enabling those attacks, right? And the more sort of fuel it's providing those attacks. And then the second part of the problem is, right, the Supreme Court may deeply believe that, those who have been attacking the lower courts understand the difference between an unelected district judge and an unelected justice, and understand the difference between defying a district court and defying the Supreme Court. I'll just say I have no such faith, and that, undermining the judiciary is undermining the judiciary. And now more than ever seems like a moment where we should all be invested in standing up for the courts, not because they're always right, but because they have a very important role to play, right, in as a bulwark against the tyranny of the majority. And given what's happening in Congress right now, I'm not so sure that it's that unrealistic to suggest that we are closer to a tyranny of the majority right now than we've been at any other moment in American history. So that's why I think these emergency cases are so important, besides their obviously really important real-world effects. It's why I think the relationship between the Supreme Court and the lower courts is so important. And it's why I worry a lot right now, not about the sort of results the Supreme Court's reaching in these cases, but about what, to me, it's not doing, right, to bolster public faith in the judiciary as an institution. And so that's where we are, and that's why I think this is a crisis. And Michael, I think that's where I am inclined to leave things off for now.
Well, that was absolutely terrific. Thank you so very much. We'll take our usual 10-second break to allow them to splice the video, and then we'll resume in a private seminar. Thank you so much.